All right, well, let's go ahead and get started. Traditionally, some of our legal presentations go right up to the very end of the end time. So we want to make sure there's opportunities to ask questions today. So we'll go ahead and start our webinar. Again, welcome. Really appreciate everyone joining us today. And if I haven't had the chance to meet you, my name is Brad Banasic. I am legal counsel for the Michigan Association of School Boards. Will be with MASB 26 years as of next month. And today I will also be joined by the Assistant Director of Legal and Labor Services, Dan Feinberg. Dan hasn't been here quite as long as me. He joined us last January, so just completed his year-long anniversary. And before coming to MASB, Dan worked in the legislature. So today we're going to be talking about the do's and don'ts of the Open Meetings Act and a quick overview of some of the topics we will be covering. I'm going to talk about some key provisions and definitions under OMA, and some subtopics relating to those provisions and definitions involve committee meetings and electronic communications. And then I will finish up with the topic of closed meetings. And then I will pass it along to Dan, and Dan's going to cover public comment, quickly touch upon the current legal restrictions relating to virtual meetings under the Open Meetings Act, and then finish up with enforcement and penalties. What happens when you don't comply with the Open Meetings Act? Now, this isn't an interactive, I guess, virtual class like we do in our CBA classes. You will not have the opportunity to ask verbal questions today, but I see a lot of folks are currently using the chat box for greetings, and that's great. But also you can use the chat box for questions. So if you have a question, whether related to the content material that we're covering today or a general Open Meetings Act question that we may not be covering, feel free to put that in the chat box. I will attempt to answer questions throughout the presentation, and Dan will as well. And we should have a little time at the end for answering questions. But the reason I put our contact information on here is you can contact us after the webinar today as well with your Open Meetings Act questions. Phone calls are always welcome. In fact, sometimes phone calls are the best way to answer a question, but emails as well. So you'll see the direct numbers for both Dan and myself and our email addresses. So on that note, let's go ahead and get started. Starting off with some essential do's under the Open Meetings Act. These are key provisions that involve key terms within the Open Meetings Act. And in order to understand these key provisions, you need to know what these key terms mean. So we'll be taking a deeper dive into these key terms within the next couple of slides. But first, let's briefly cover these key provisions. So the most general requirement of the Open Meetings Act is that all meetings of a public body shall be open to the public. And you'll note that I have the term meetings and public body both highlighted in bold. So we'll be looking at interpretations of those terms by courts and the Attorney General. Next requirement, all deliberations of a public body that involve a quorum of the board or quorum of members shall take place at a meeting open to the public unless a closed meeting applies. And then the next requirement, all decisions must be made at a meeting open to the public. So it's important to distinguish, what constitutes deliberations and what are decisions under OMA, particularly when you're in closed session, because you cannot make a decision in closed session. While you can deliberate as a quorum in open session, deliberate as a quorum while in closed session, that doesn't carry over to closed sessions. You can only deliberate in closed sessions. You cannot make a decision while you're in a closed meeting. So we'll take a look at distinguishing those two terms, and particularly in the context of meeting in a closed session. So the definition of a public body, this comes straight from the Open Meetings Act. As you can see, it clearly covers a school board. A school board is a local governing body, and it may cover a committee as well, because a district is governed by its school board. A committee of the school board is a governing committee for the purpose of this definition. Now, note that this would not cover entities like your booster clubs or a PTA or a PTO. While those groups have a very close relationship with school boards and school districts, they're not considered a public body for the Open Meetings Act or for the Freedom of Information Act, for that matter. So they are not subject, to the open meetings requirements, a booster club board or PTO board, and if someone made a public records request to your local, to an athletic booster club or a PTA, they would not have to respond to that public records request. So the definition in the context of a school district and public body essentially only applies to a school board and possibly its committees, which is the next question we're going to address. Is a school board committee a public body for the purposes of the Open Meetings Act? And there's some analysis involved in determining whether your committees are a public body and then meet that threshold of being subject to the requirements of OMA. You look at whether that committee has been authorized to perform a governmental function on behalf of the board. And if that's the case, that committee becomes a public body. So it must be empowered to act on matters that would deprive the full school board of an opportunity to vote on that issue. And that, in essence, is the committee exercising governmental authority. And that would make the committee subject to the Open Meetings Act, even if it doesn't involve a quorum of the board. So you could have a committee of 3 board members, whether it's an ad hoc committee or a standing committee, and that committee would be subject to the Open Meetings Act. It's empowered to act on matters that deprive the full board of voting on that particular issue, and then it would be engaging in the exercise of governmental authority. Now, on the other hand, if the committee is just gathering information and is not making a decision on behalf of the board, maybe making a limited recommendation with other options, then it's not subject to the requirements of OMA. So a question here in the chat box, can someone serve on a PTO board and a school board? Yes, not covered under our conflict of interest laws. So we have a law called the Incompatible Public Offices Law that prohibits school board members from working in a school district or maybe serving in other public positions, because a PTO board, as we discussed, is not a public position, not a public body under the Open Meetings Act. The Incompatible Office Law would not apply to that situation. So yes, someone can serve on both a school board and a PTO board, or maybe an athletic booster board. So good question. So some takeaways from Open Meetings Act cases. There's been a number of cases. And that's why the analysis can be a little bit tricky in determining whether committees are subject to the Open Meetings Act or not. These cases started back in the mid-1990s with a case called Booth Newspapers versus U of M Board of Regents. And that was the initial case that determined that in some cases, committees of a public body are subject to the requirements of the Open Meetings Act. And then after the Booth case, a number of cases, at least topping 20 cases from the 1990s up until now, addressing the issue of whether committees are public bodies for the purposes of OMA. So some key takeaways from those cases. In order for a committee to be truly advisory and not subject to the Open Meetings Act, the committee would have to identify preferred options and recommend them to the full school board. So the committee, we're gathering information and we've made a recommendation on a matter, but full board, you could choose these other options as well. And then the board obviously retains the authority to vote on accepting or rejecting the recommendations. And there should be a vote. If there's not a vote and maybe the committee recommends the status quo on a particular issue after it's gathered all this information and recommends, okay, we're not going to change things. We're just going to recommend the status quo. The board needs to act on that if you don't want your committee subject to the Open Meetings Act. If the board doesn't act, then technically the committee has made a decision without subsequent action from the full board. And then the last bullet point here, committee will likely be subject to OMA if it engages in the practice of eliminating or narrowing down options. The committee would be exercising authority, precluding those matters from reaching the full board for deliberation and decisions. So it's always been MASB's longstanding practice to say this analysis can be complicated, and thus the best practice is just to go ahead and treat all your committees as public bodies under the Open Meetings Act. So if you're going to do that, whether your committee is legitimately and legally a public body under OMA, or you feel like it's just the best practice and you're going to follow MASB's recommendation of treating all committees as public bodies under OMA, then you would have to post notice of the committee meetings. Obviously, those meetings would be available to the public. And then you'd have to include an opportunity for public comment as well. If the committee is going to be making decisions, those decisions would have to be made in open session, and the committee could take minutes. Now, again, if you're addressing a closed meeting topic, the committee could actually go into closed session as well if it's addressing a confidential matter that's covered by one of the closed meeting session topics that we're going to be talking a little bit about later on in the presentation. So a couple of questions. Are postings required for committee meetings? If they're subject to the Open Meetings Act through the analysis, then yes, clearly the postings would be required. How does identifying preferred options differ from narrowing down options? Ultimately, it depends upon whether the board is making the final decision. If narrowing down options, if you don't provide all the other options to the board, if the board hasn't had an opportunity to maybe vote or consider those other options that have been narrowed out, then the committee is making a decision. Can a person serve on a school library board or serve on a school board and a library board? Not to get too far off the beaten path here and making this into a conflict of interest presentation, but in that case, you would look at whether there is a relationship between the library board and the school board, which would require that person to represent both interests, which would be difficult to do. So if there's a contract between the school board and the library board, and that individual would have to abstain due to that contract, then it's an incompatible situation. Abstaining does not correct that incompatible issue, and then the person would have to resign from one of the two boards. So that finishes up our discussion on committees. And I know that's been a big issue lately for a lot of school boards. I've been getting tons of questions on committees. Hopefully, that analysis we just provides some clarity to the issue. But if you still have some questions on committee, feel free to follow up with Dan or myself on that, or maybe put another question in the chat box if you need further clarification. So let's look at the term meeting and the significance of that. So the definition, involves a quorum of a public body, which a quorum is present for the purpose of deliberating toward and rendering a decision on public policy. Now that's an important or there. It's not an and. It's not deliberating toward and rendering a decision on public policy. It's deliberating toward or rendering a decision on public policy, which means taking action is not a threshold requirement for having a meeting under the Open Meetings Act. Even when a quorum of the board is just deliberating on matters, whether it's at a work session or a retreat or a study session, that still qualifies as a meeting under the Open Meetings Act. Okay, so your workshops, retreats, study sessions, committee of the whole meetings, all those discussion-only gatherings still qualify as meetings under this definition under the Open Meetings Act. Now, there may be some cases when you don't have a quorum present and it's still a meeting under the Open Meetings Act. Now, we just talked about committees and sub-quorum meeting, being subject to the Open Meetings Act because that committee is a public body. Now, outside of a committee meeting, you could still have a meeting under OMA if you splinter the quorum or create a constructive quorum. So what does that mean? It means that first you initially have discussions that involve less than a quorum of your school board, so a traditional 7-member board, those discussions are between 2 or 3 board members, which would not be a meeting under the Open Meetings Act if it's not a committee acting as a public body. But then those discussions amongst those 2 or 3 board members are shared with and communicated to other board members. So the total number deliberating constitutes a quorum of the board. In that case, that would be a meeting, and there would have to be compliance with the Open Meetings Act. So let's take a look at an example of that. Real life situation here involved a school board a number of years ago. So you had members of the school board that were going to meet with staff members without the administration being present. So from a governance perspective, that's a bad idea to begin with. And then it gets worse. The meeting began with 3 members, but then a 4th board member showed up. Said, well, I want to be involved in this. I want to hear what the staff members have to say. And this wasn't a gathering posted as a meeting under the Open Meetings Act, because the expectation was it would involve only 3 board members. So the board members got creative and said, well, let's have a tag team meeting. 4th board member, you wait outside the room for 15 minutes. And then when we give you the signal, you come in, and then we'll send somebody else out. So there will only be 3 of us physically present in this room at one time. So we're good under the Open Meetings Act, at least so they thought. Well, this was reported to the prosecutor because someone thought this doesn't seem quite right. And the prosecutor investigated, and sure enough, yeah, this constituted a constructive quorum and was a meeting of the school board, and thus should have been held in compliance with OMA. Obviously, because it was not held in compliance with OMA, it was a violation of the Open Meetings Act. And Dan will talk a little later about what happens when you violate the Open Meetings Act. So an example here of splintering the quorum, you want to make sure that if you're having separate mini meetings, meetings of 2 or 3 board members, and these meetings are very informal, and you're discussing school district business, that's okay, but then you can't share what's been discussed in those meetings with other members of the board. That creates a constructive quorum and would violate the Open Meetings Act. Can a quorum of the board ever gather outside of a public meeting? So let's go the other way. A meeting when you have less than a quorum of the board physically present at one time, falling within the definition of a meeting. But here you have a quorum that is physically together at one time, but it's not a meeting under the Open Meetings Act, because there are some exceptions to OMA when a quorum can be physically present together and it doesn't constitute a meeting. It doesn't fit within that definition of a meeting under the Open Meetings Act. So the first one I like to refer to as the MASB exception, where you can go to an MASB conference together as a quorum of the board, or let's say your whole board decides to go to our annual ALC. That's completely fine. Does not have to be posted as a meeting under the Open Meetings Act due to this exception. But there are 3 important elements that must be met. First one, the conference must involve issues broader than those which affect the particular board. Clearly the case with MASB's ALC. Open to other members of other school boards. Again, everyone's invited to our conference. And then lastly, while you're at the conference, you have to refrain from any collective discussion as a quorum about information you learn at our conference. So you attended a great clinic session on superintendent evaluations, and you have lunch right after that. You're having lunch with 4 or 5 other members of the board. You can't discuss what you heard in that clinic session and how you're going to apply it in your school district. That has to be reserved for a school board meeting. Cannot be discussed during your lunch. Now, another situation where this would not apply, this exception would not apply, would be when MASB comes to your school board and does a training. So you bring in Brad Banasek to do OMA training for your school board. Yes, it's considering issues broader than what are specific to your school board, because OMA applies to everyone. However, it's just for your school board. It's not open to other school boards. It's just for your board. So then it doesn't meet this exception. So if I'm coming in to do an Open Meetings Act workshop for your board, that would still have to be posted as a meeting under the Open Meetings Act, would not fit in to this exception. So a few more to take a look at. The social or chance gathering exception, this is the one that applies most often. Just board members randomly showing up together at an athletic event or a fine arts event. And then we have graduation coming up in the next month or so. Quorum of the board is traditionally at the commencement ceremony to recognize your graduating seniors. That doesn't have to be posted as a meeting under the Open Meetings Act. That is a social gathering, so to speak. One question that's been coming up frequently about building tours. Let's say you're starting a construction, or you're in the midst of building construction, or you're just about ready to complete construction. Can the board tour the construction? And would that have to be posted as a meeting under the Open Meetings Act? In my opinion, it would fit into this social or chance gathering exception. But while the board is touring the buildings, you would have to ensure that you're not having any discussions relating to the mission of the district or school district or school board business while you're doing those building tours. Presentations by groups. This would allow a quorum of the board to attend a community meeting offered by your Kiwanis Club or another public body such as the city council. The board can attend that as a quorum, but while you're there as a quorum of the board, be sure not to deliberate as a quorum. And then lastly, this one hasn't come up or wasn't applied that much previously until this last election. But what we saw on some school boards, you had slates of candidates running together. So let's say you had 4 board members who are up for re-election, and they were being opposed by maybe a slate of 4 new board members who wanted to unseat those current board members. Well, those current board members could run together as a slate, and even though they involve a quorum of the board, they could meet together to discuss strategy to how to win their election. That would fit within this political matters exception. So the board's getting together, discussing purely political matters, personal concern to those 4 board members. Their concern is, yeah, we want to get reelected, and they're not considering matters of public policy. And again, while the 4 board members are strategizing on getting reelected, they should keep off limits any discussion relating to their current school board duties and responsibilities. What about texts or emails? Could you have an electronic meeting that would be in violation of the Open Meetings Act by electronic communications via texts or emails? Yes, could violate the Open Meetings Act. A meeting occurs electronically if a quorum of the board is deliberating on matters or making a decision on a public matter outside of a public meeting. Now, a 2-way email exchange between board members, that is fine if it's just limited to 2 board members, no issue there. And also, OMA doesn't prohibit your superintendent or your executive assistant from sending out an email blast to 7 board members. The key is how you reply to that. You don't want to hit reply all in response to that information that may constitute deliberations on that information. That should take place at your upcoming meeting rather than by email. So some email best practices here. First example I just gave, do not hit the reply all button. Be careful with sequential communications. That's chain of emails adding up to a quorum of the board. So that's akin to creating that constructive quorum or splintering the quorum. Consider using blind copies. Now, I'm not going to say using blind copies is a fail-safe way to avoid any type of OMA violation with emails, because if you send out 15 messages within a 1 or 2 hour span and you use blind copies, most likely, even with those blind copies, you could still have deliberations by a quorum of the board. So it's a good practice, but not a fail-safe way to avoid all OMA violations with emails. And then you can include a disclaimer. You can find this in our Open Meetings Guide. This reminding colleagues on your school board, be careful with this message. We don't want it to result in deliberations by a quorum of the board, so it shouldn't be used for interactive discussion purposes, and it shouldn't be forwarded to other individuals with comments as well. Don't text during board meetings. Now, this is, I will say, a non-binding guidance by the Attorney General. If you've seen the Attorney General's handbook on OMA, you would find this guidance in there, but I think it's good guidance to follow. This would be two board members texting each other at a public meeting. Okay, how are you going to vote on this? Oh, I agree. I think that's a good way to vote. Back and forth texting, those are deliberations, and the Open Meetings Act requires all deliberations by board members at an open session to be public. So you can't have secret deliberations while you're in an open meeting. So that's why the AG has found texting or emailing amongst board members, that would be secret deliberations, and in fact, a closed session, which it would not be permitted under the circumstances, and thus a violation under the Open Meetings Act. So avoid any type of electronic communications amongst board members during a public meeting. Take a look at the term decision now. So, distinguish this from deliberations, particularly in the context of meeting in a closed session. So a consensus building process can still be a decision under the Open Meetings Act. So again, no decisions outside of a public meeting. You don't want to use electronic communications or sub-quorum meetings to make decisions outside of an open meeting, and you should not be using electronic communications to make a decision outside of an open meeting as well. What you can do is canvass other members of the board, okay? That would be contacting your 6 other colleagues and seeing how they're going to vote on a matter. This is a situation that usually comes into play when you're electing officers. So I want to nominate Dan for board president, but I want to nominate him unless he's going to get actually elected. So I can canvass my 5 other members of the board and say, if I nominate Dan, can I count on your vote for him to be elected a board president? And that's permissible, as long as it's done one-on-one. Now, it could turn into splintering the quorum if you go down the line and say, well, I talked to Larissa and I talked to Mackenzie. They're both supporting my nomination for Dan. I just need another vote then to ensure I have 4 votes. Can I count on your vote? At that point, I've splintered the quorum, and that's a problem and likely a violation under the Open Meetings Act. So a quick question in the email: would email practices apply to text messages as well, or the email best practices? Yeah, I think you could apply those to text messages. I think that would be a good idea. If someone is recommended to be vice president or president, can that person vote for themselves? Most definitely. Not a conflict of interest to vote for yourself in an officer position. In fact, you should be voting for all officer positions when you're on the board. Another question here. While I'm referring to a quorum, that is a majority of the school board. So a 7-member board, a quorum is 4, regardless of how many people are at the meeting. Or possibly have conflicts of interest and they can't vote on something. So 7-member board, quorum is 4. If you're on an ISD board, your quorum, if you have 5 members on the ISD board, your quorum would be 3. We do have a few 9-member boards out there. Obviously, then their quorum would be 5. So a majority of the board constitutes a quorum. Another question: what about a board member having an online conversation during an open meeting with someone not on the board, someone in the public, text, Facebook message? I would say that is not a good practice from a governance perspective, likely not a violation of the Open Meetings Act, because that person's not another member of the public body. Now, if the person was a board member and couldn't attend the meeting, and this person was having a conversation with this other board member who couldn't attend, I would say that would be problematic from a legal perspective. But if it's someone from the public, again, not a practice I would recommend, but would not be a violation under OMA. Question: prior slide, what is the blind copy different from a carbon copy? With the CC, you can tell who's being copied. On a blind copy, you can't tell who's being copied. So that's the difference between the two. Okay, moving on. So conduct in order to ensure that you're following the requirement of all decisions being made in a public meeting. You have to conduct votes in such a way that a person attending the meeting or reading the minutes can hear or see how each board member votes. Okay, that's the standard you use as a school board. Are we taking votes in a way so the public can hear and see how each person's voting, and also that's reflected in the minutes as well? Under no circumstances do you use secret ballots, okay? Do not use secret ballots. If you use a ballot process for anything, maybe electing officers, then you have to disclose publicly what those ballots indicate. So all ballots must be transparent. You cannot have any secret ballots to kind of formulate a pre-decision or a final decision. Okay, don't make decisions in closed meetings. This is kind of what I've been leading to when looking at the definition of a decision. Court of Appeals, Supreme Court ruled that even using an informal voting procedure in a closed meeting violates the Open Meetings Act. Okay, that would be the situation. Board president saying, okay, this is a very significant issue of closing the school building. We've reviewed our attorney-client privilege document here in closed session. I just want to make sure we're all on the same page here. So show of hands, who believes we should close the elementary building? At that point, you've crossed the line. Okay, you've gone from deliberating to making a decision in closed session, and that violates the Open Meetings Act. Now there is this one very limited exception to this. You can see the third bullet point here. When you're in closed session under section 8C, discussing strategy relating to negotiations in closed session, you can reach a consensus on collective bargaining strategy. Where to hold strong, what are we going to give up, how we would vote on this particular letter of agreement. That's a very limited exception, only applies to 8C, which we'll get to in a minute. But that is really the only time you can make a decision in closed session. Could a board member say, I'm going to vote this way? Do I have support on that? I would not recommend that, sir. I do not believe that would be a good practice to do in closed session. All right, my top 5 meeting don'ts. And we'll get to closed meeting exceptions in a minute. But before doing that, avoid these type of closed meeting situations. Exceeding the scope of the closed session. That's when you're legitimately in closed session, and then you have closed session creep that takes you to another topic in closed session that isn't covered by a closed meeting exception. You've exceeded the scope of that closed session, violation of the Open Meetings Act. Discussing an oral legal opinion from legal counsel without a pending lawsuit. We'll look at the pending litigation exception in a minute for a closed meeting, but there's also an exception that allows you to go into closed session and discuss a written opinion from your legal counsel. It has to be a written opinion, cannot be an oral opinion in order to be discussed in closed session. Citing personnel matters as a reason for calling a closed meeting. Yes, there are specific closed personnel matters that apply to closed meetings. You have to identify what those are. You just simply can't say meeting in closed session and consider personnel matters. We'll see what those specific personnel matters are in a bit on the next slide. You can't discuss your superintendent's contract in closed session, okay? There is an exception that allows going into closed session for collective bargaining of a collective bargaining agreement or negotiating a collective bargaining agreement, but does not apply to superintendent contracts. And then lastly, we just talked about you can't make a decision in closed session. You deliberate. You always stop short of going into decision land and violating the Open Meetings Act. That's up to your board president. Your board president, that person's the gatekeeper of your closed session, ensuring that you're legitimately in closed session. And while you're in there, you're not exceeding the scope of the closed session or you're making a decision in closed session. A few questions here. Closed meeting, can you express that you disagree with the topic? Yes, you can express opinion. That is fine. Superintendent review. So evaluations, good question to lead into the next slide here. All right. These are the closed meeting dues. These reasons allow you to legally meet in closed session. Number one, considering complaints, disciplines, and evaluations relating to employees or board members if requested by the employee. So number one would cover the superintendent evaluations, but note that this one, it covers those personnel reasons, but it has to be requested by the employee. Thus, the board does not have independent authority to go into any of these closed meeting sessions. Has to be requested by the employee who's subject to the complaint, discipline, or in the superintendent's case, the evaluation. Number two is similar, considering student discipline. If requested by the parent or student, can only consider student discipline in closed session at the parent's request, or if the student's 18 at the student's request. For strategy negotiation sessions connected to a CBA, that's what I mentioned previously. Purchase of property. Note that this does not cover selling property. So if you're in closed session, selling an old vacant elementary school, you better have a legal opinion on selling that school from your legal counsel, because it would not be covered by number 4, because that only covers purchasing property, not selling property. Number 5, consulting with an attorney on specific pending litigation. In this one, there has to be a pending lawsuit. So you've received the proof of service from the court. Your attorney has to be present for this exception. And then you see this little asterisk that requires a 2/3 vote as well from the board. So 4 requires a 2/3 vote as in addition to 5, 6, 7, and 8, meaning that you have to have 5 board members present in order to go under the closed session under 4, 5, 6, 7, and 8. For 1, 2, and 3, simple majority vote would be permissible. Okay. Reviewing applications for employment to public office or appointment to public office. If confidentiality is requested, this exception could apply during a superintendent search. It's very common for superintendent applicants to request confidentiality because they're currently working in another school district. If confidentiality has been questioned, which is likely, or has been requested, which is likely the case, then you may go into closed session only to review the applications. This is an exception that is susceptible to the closed meeting creep, where you could start discussing, okay, these are the best candidates, so I suggest we interview these 3 candidates. And that's discussed in closed session. That's not permissible. Okay. Be careful with that exception. Number 7, that's your attorney-client privilege exception. FOIA does not, or FOIA makes a written opinion from your retained legal counsel confidential. So it would not have to be disclosed under a FOIA request. FOIA is the Freedom of Information Act. Because that written opinion is confidential under FOIA, you can take it into closed session under OMA, but it has to be a written opinion. And then lastly, considering security planning to address existing threats or prevent potential threats, that would be, okay, we're going to revise our security plans to address this very specific issue, and the board can go into closed session to review that security plan, because you don't want the bad people to know what your plans are. Those should be kept confidential, and that's why you can discuss those in closed session. And that leads us to the next slide. And at this point, I'm going to stop sharing my screen and hand it over to Dan Feinberg to bring it home.
Hello, everybody. Let me just get my screens all lined up here. And let's see. Okay. Thanks, Brad. Picking up with public comment at board meetings. This has been an issue that came up a lot in the pandemic, where we went from school board meetings with very few people to school board meetings with many people, all with something to say. The statute says a person must be permitted to address a meeting of a public body under the rules established and recorded by the public body. So the rules have to be reasonable and flexible. They have to be written in a way that encourages public participation. You're talking about First Amendment rights for people to address the board and address their governments. So you have to be very careful when you're dealing with free speech rights. School board's public participation rules. They're there to assist in balancing the board's interest in conducting a meeting that's going to run well and be orderly and get things done versus those individuals' rights to express their opinions about this thing. Let's see. So public comments, the length of the public comment is an issue. MASB advises that the time limit, if you're going to put one in, should be no less than 3 minutes. If somebody's getting up there with less than 3 minutes, they're not going to get through their throat clearing before their time is up, and you could run into a problem. The other issue with the timing is you have to be sure you enforce it consistently. If you let the people that are waxing eloquent and saying nice things about you go longer, and the person that is coming after you, if you're cutting them off right at 3 minutes, you're going to run into issues that are going to come up from that. In your bylaws, if you are going to limit the amount of time that you have for public comment, you have to be sure that you are not using it to cut people off from being able to speak. You say you have 30 minutes and you deny people. If you say we've done our 30 minutes, we're going to do a second public comment period at the end to catch all the other people that, because we needed to move our agenda along, you have to be sure you have time for them after. If you just say, sorry, we've hit our 30 minutes, we're done, then you're going to end up violating OMA. So an issue that's come up as part of the question in the organization of the meetings is using public comment forms. It is reasonable to have them, to have people identify themselves. So you have a list, you know how many people are going to be coming up. That was an Attorney General's opinion from 1977. Recently, there was a case that came forward. It's an unpublished opinion, but it gives some good guidance on this. The Court of Appeals affirmed that a school board's public comment form was a reasonable rule or regulation established to avoid disruptions at a meeting. What they had done is they had brought a form in that just requested people to put their name, couple pieces of information. They wanted them to fill it out. They didn't require all of it. And that would put them on the list for public comment. The individuals that brought the case, Redmond and a couple others, they had said that they were uncomfortable with the form, and they said that the form was not adopted in the policy, so it didn't count. And the court said the form is fine. The reasonable rule and regulation, they said it was reasonable. They said that they met the requirements for putting it in. It had to be in some sort of written medium, and there was a form. There was a letter at the front, a sign that said, "Please fill out this form." The court said that meets those requirements. In another aspect of it, the board actually went and adopted in their policy as the litigation was going on. They added the form into their actual policy, which addressed the issue and made a lot of the challenges moot. I'll talk a little bit more about that when we move a couple more slides. There is one unanswered question that is still out there of the timing. So generally, if you're allowing people to fill out the forms up to the meeting, and then you collect them at the beginning of the meeting and say, we're done here, we've closed the collection of those documents and begun our meeting, it's unclear where the court would come down on saying whether or not somebody should be able to turn in a form up into the end of public comment or not. As well, it is not answered whether or not you could close that period 3 days earlier. Generally, I would recommend not doing that, but just be aware that that question is still out there of when a cutoff period could be. Let's see, there's a question here. As individuals are allowed to address the school board in public comment, to what extent are individuals allowed to use disrespectful language, badger, or threaten board members? Interestingly, that's where we're going on this. So public comments and complaints. So Under the First Amendment, a board cannot adopt a rule in its bylaws that prohibits citizens from publicly criticizing or making complaints against school employees by name during public comment. Excuse me, that was a long breath. You can, however, encourage citizens to use their complaints against individuals, teachers, staff, the board through administrative channels, and before requesting board consideration. Comments that constitute a personal attack on an employee or board member, if they're totally unrelated to his or her duties, may be prohibited. So if someone is attacking a board member and they're using disrespectful language, but it's related to the board activities, people can use coarse language. You can request that they be respectful, but they're not required to be. If they're attacking board members or employees in other manners, if they're going after them saying, I think these people are jerks and, they cut me off while driving or what have you, it's not related to their function with the school. That is language you can cut down. You can stop them from that attack because it's not related to their duties. And then in controlling complaints, one of the issues that we recommend is some language that you can use, basically putting out, you could read it as a statement at the beginning if you have contentious issues, or put it out in posting. To ensure due process and respect of individual rights, the district maintains its formal process of handling complaints against individuals. Problems involving an individual or specific incident are best handled through administrative channels. For assistance, please contact the superintendent's office. Hopefully that will divert some people into a proper process. And then as to the civility issue, speakers are asked to express themselves in a civil manner with due respect and dignity and privacy for others that may be affected by your comments. While it's not our intent to stifle public comment, speakers should be aware that if your statement violates the rights of others under the law of defamation or invasion of privacy, you may be held legally responsible. If you are unsure of the legal ramifications of what you are about to say, we urge you to consult first with your legal advisor. This language allows for the person to still say what they wish to say if they choose to say it, but it should give them a little pause to realize that if they're about to unload on somebody, that they might take into consideration defamation issues. Again, coarse language or disrespectful language, they have that right to act that way. Or speak that way. If you've limited your time down to 3 minutes and you stop them from that, you can reiterate between speakers the question of civility. Is it required to have the speakers state their name and address? Is there some benefit to it, or why it was started? You can request that they do it. Certainly stating their name, their address, you can request it, you can't mandate it. The benefit of and why it had started, and why people want that information, is if somebody who does not live in the district and does not have any real attachment to the district outside of a political axe to grind comes in from across state, they're not really, their interest isn't in the district, it's in whatever their issue is that they're bringing up. Is that really of value to the district that they be there? Now, they do have the right to come in and speak to the district, but requesting for an address helps you to understand more so, is this a constituent? Is this a resident of the district? Is this someone we need to have our contact with and address further if we need to? Or is this somebody that's just kind of coming in and then they're going to disappear and feel like they've achieved what they wanted to achieve? So yes, asking for it, you can, demanding it and requiring it, that crosses it over a line. Moving on to OMA and virtual meetings, as everybody still probably has fresh in their minds during the pandemic, a lot of governmental meetings went virtual. That has gone away. So now the only members of the military can vote and participate in public meetings by virtual means. If their physical absence is due to military duty. So if somebody is shipped out, they can still participate. They have to go through certain steps. That is the only way. If somebody is ill, they're not allowed to come in. You cannot, OMA no longer permits a school board to conduct a virtual meeting in whole or in part to accommodate members who have a medical condition or are subject to local or state emergency. So all of the pandemic rules and changes have gone by the wayside. The OMA does not clarify whether conducting a virtual meeting in part means allowing an individual board to participate virtually or vote. So it's a blanket thing. If you are not in the military, you need to be present in order to participate. So erring on the side of complying with OMA, MASB interprets the virtual meeting requirement very broadly. So any type of virtual involvement, as we just said, you need to be there physically present to participate. Asking if you can just listen in as a board member and not vote isn't an option. You can, like, if you come in as a board member listening, you can't do that. But if you do want to listen as a participant in the audience, if you're broadcasting your meetings over cable access, an example, the board member could watch it on cable access, or if it's being broadcast virtually and there's not a interactive aspect, they can do that. Absent board member can do that, but they can't just phone in as the board and listen or engage in the deliberation but not vote. That is not permissible. Let's see. Can the superintendent zoom in? Yes. Interestingly, the board can be present. The superintendent is not a board member, so they would be able to zoom in if they needed to. The other aspect of this, if you have presentations from organizations that want to come in, you can schedule to have them zoom in. So other people can participate from Zoom, but board members cannot. So if, like I said, if it's being live streamed, then physically absent board members can view and observe. Let's see. The OMA does not expressly require or prohibit a board from conducting a public meeting that allows allows community members to attend to engage in public comment. So you can allow for the public comment to come in virtually. That's a decision that you make as a local board. If you choose to do that, be aware that all members from the public that are wanting to do that, if you pick and choose, that could run you into a problem with that, in that you're not allowing certain people. So that can be fraught with issues. If you don't allow it at all, then it's a blanket, you just want people present for it. Let's see, if a traditional in-person school board meeting is held without complying with 3A virtual meeting requirements, there would be some uncertainty as to what type of rules could be applied to administering virtual public comment. As I said, I think you could, if you didn't allow it at all, then you're covering an entire segment. You're not picking and choosing who can and can't speak. MASB recommends that the board limit public comment to individuals who are attending the meeting in person. As we were saying, it can get ugly. If you keep it just to the people that are present, you won't have trouble with that aspect. Moving on to an attorney general's opinion that came out last February, so a little over a year ago, the ADA and how it's implicated. So the ADA requires public bodies to provide reasonable accommodations, which could include an option to participate virtually to qualified individuals with a disability who request an accommodation in order to fully participate as a board member or a community member in meetings required under the OMA to be held in a place available in general public. So this adds a little bit of a hitch to the virtual participation. Once those rules expired, this opinion came out. To the best of my knowledge, it has not been tested yet, but under the ADA, if a person meets the requirements, so they have a disability, the question would come up if the disability was recognized as being one that qualified under ADA, then would a virtual accommodation need to be made? Whether that's for a board member or for a public participant, and those can vary. So the example is if you have somebody who has a disability, they're immunocompromised from a cancer treatment, and that board member requests accommodation to participate in a vote. In the opinion of the Attorney General, the district should accommodate the board member by providing virtual access. As I said, to the best of my knowledge, this has not been tested yet. The question would be what meets the requirement under the ADA. Somebody who is 98 years old, immunocompromised, is suffering from multiple ailments, bringing them into a room might be, they might qualify because their illness is an ongoing concern. Somebody who has COVID or the flu or passing illness, while it might be a smart idea for them not to show up into a room and infect other people, that likely wouldn't qualify under the ADA as a disability. So that might not rise to the requirement. So this is an area that's going to develop. Enforcement and penalties of the OMA. There are civil liabilities if a public official intentionally violates the act on a personal level in a civil case for up to $500 plus court costs. So the issue there, it would have to be proven that it was an intentional violation. Criminal penalties, the public official who intentionally violates the act may be guilty of a criminal misdemeanor. The maximum penalty for 1,000, second offenses go up. Again, the issue would be showing intention of the action. The big thing that the courts can do is invalidation. So if a decision was made by the board and it turns out that it was a violation of the OMA, that decision could be invalidated, meaning the board would have to redo that decision. I talked a little bit about it early on as far as the Redmond case. They went back and they specifically added the things that were in question into their policy, redoing it. They redid it before any decision of the court, which led to mootness of the question. But ultimately, that would be the big issue that would come up, that if a board had to make a very difficult decision and somebody brought up and won saying that it was a violation of the OMA that it was handled, they would have to go through the steps of that difficult decision again. Let's see, a couple of last questions here. Can the public make a question via virtual means? That depends on the board's decision if they want to allow that or not. Do the virtual meeting requirements also apply to board committee meetings? Yes, if it is a posted meeting, if you are making it as a meeting, the virtual requirements would still apply. Let's see, information for the presentation meant to be just for new board members. Could it be shared with? So yes, of course, we can share that. How long can you have recordings of a meeting available on your school website for community members to watch? The thing that you have to keep are minutes. Recordings after the minutes have been adopted can disappear. So it's your decision how long you wish to keep it there. I've seen them there forever. I've seen them disappear very quickly. That's 12:59. Are there other questions?
I had a few questions, Dan, that I didn't get to during my part of the presentation. I'll quickly address those now. So what about appointing new board members due to unplanned vacancy? Can you discuss those candidate applications in closed meeting? Yes, you can if they request confidentiality. Most cases, your school board candidates are not going to request confidentiality if you're reviewing applications for filling a vacancy. And as a best practice, I advise not using that exception, even if candidates have requested confidentiality while filling a board vacancy. There shouldn't be any confidentiality issues associated with filling a school board vacancy. Now, clearly, when you're filling a superintendent vacancy, you have those confidentiality issues, but not filling a school board vacancy. So while it would be permitted under that exception, I don't advise utilizing it. And then another question, just wanted to confirm that a board member can request closed session for a student, can't request a closed session for a student hearing. That is the case under section 8B. Now, there may be times when you have a student expulsion hearing set up and you hear nothing back from the student or parent. Silence. And you're still going to expel the student and they haven't requested a closed session or open session one way or the other. In that case, you would go down to section 8H under the Open Meetings Act, which allows you to discuss education records in closed session under the Family Educational Rights and Privacy Act. So you would be discussing information that's considered to be confidential under another law. And you would be, anytime you're having a discipline hearing, you're obviously going to be discussing education records. So in that situation, the parent would not be able to request, or the parent does not have to request a closed session for the board to meet in closed session to consider student discipline. I see question here, is the superintendent contract visible on the district's website? No, it is not. You're not required to post the superintendent's contract on the district's webpage. All right, I think we got it covered, Dan. See anything else?
Nope.
All right, well, thanks again, everybody, for joining us today. Thanks to Mackenzie and Larissa as well for their support. Congratulations on your election to the board. We look forward to working with everyone going forward. Hope to see you, in a CBA class or on our 2023 ALC. But as we indicated earlier, if Dan and I can be of any assistance answering questions, please don't hesitate to reach out. So thanks again, everybody. Have a great rest of the day.